Swayam Prabha. Digital India. Educated India.
Hello everyone. So, as we last 4 lectures we have discussed of our course on medical law. So, hopefully all you have gone through the lecture 1, 2, 3 and 4. So, first was the introduction, how it evolved. Second was the role of doctors or the practitioner in the justice. Third, what is the do's and the don'ts of the doctor or medical professional. So, fourth was the do's and the don'ts of lawyers. So, today coming to the lecture 5 of our course medical law, knowledge exchange between medical and the legal practitioners. So, today we will be discussing the various concepts which comes under this lecture. The need for knowledge exchange between medical and the legal practitioners. Medical practitioners having the legal knowledge, or another way around, the legal practitioner should have the medical knowledge, and then the amalgamation of both the professions, that is the medical and the law, into doctors and the lawyers. So, various keywords involved to our lecture 5 is paternalism, autonomy of patient, professional standards, doctor, lawyer. So, coming to the introduction, when we consider the connections between law and medicine, we must recognize that these connections must be made primarily through the lawyer on one hand and the doctor on the another. Attempts have been made at the educational level to make lawyers and the doctors more or less familiar with each other's science and art. For many years, courses in medical legal subjects have been taught in some medical schools. So, why this exchange of knowledge is needed? Why there should have an exchange of knowledge between lawyers and the doctors? Legal professionals and members of a jury frequently encounter legal situation that necessitates a grasp of specific knowledge beyond their typical educational background. Legal cases may involve areas such as medicine and other scientific disciplines, toxicology, ballistic or engineering or any forensic science branch, wherever their knowledge is being required in that particular legal case. The acquisition of this specific knowledge can be attributed to formal professional education and extensive practical experience over a significant period of time. The potential exacerbation of the knowledge gap between legal specialists and science experts can be attributed to the divergent procedures and modes of thought employed in the respective domains of law and natural sciences such as medicine. In a similar manner, the utilization of scientific terminology establishes certain conceptions and definitions for phrases that may not align with the terminology employed by those lacking specialized scientific knowledge or expertise in the legal field. So, coming to the medical practitioner with a legal knowledge, why the medical practitioner should have the legal knowledge. So, that is the medical jurisprudence. There is a significant lack of awareness among physicians regarding the legal standards that govern patient autonomy, confidentiality, and access to health data. To improve physicians' legal knowledge and level of compliance, there should be law classes required in all levels of medical education, beginning with the undergraduate level. So, this course is being made for them to learn a basic law knowledge. A comprehensive comprehension of medical legislation is of utmost importance, as it has a substantial influence on legal adherence and consequently the preservation of patients' rights. Physicians who fail to comply with the law may face substantial risk in the event of malpractice claims. So, coming to the need of medical knowledge in the legal arena. The legal or the law practitioner should also know the medical knowledge. Medical or scientific knowledge can be introduced into legal proceedings through the different means. This can include expert statements provided by the treating physician. In the context of criminal law and mental health, the testimony of a mental health professional might either serve as a means of exonerating an individual or resulting in their institutionalization. In the domain of insurance law, it is noteworthy that legal determination pertaining to compensation claims for specific illness might be influenced by the inclusion of statements provided by medical experts. So, help in avoiding litigation. In recent years, there has been a notable increase in instances of violence and legal actions directed towards medical practitioners. This trend can be attributed to a growing awareness among individuals regarding their rights, resulting in a shift away from the traditional doctor-patient relationship characterized by paternalism. The autonomy of patients is an essential requirement in contemporary society, and thus patients who are inquisitive, knowledgeable, and discerning are increasingly inclined to pursue legal action. In addition to their standard medical curriculum, it is imperative for all medical practitioners to possess a comprehensive awareness of the legal framework inside their respective countries. The acquisition of knowledge pertaining to the management of medico legal matters such as medical negligence, medical malpractice is crucial in mitigating legal disputes raised against the doctor themselves. Aids in upholding patients' right. From the outset, from the beginning, the individuals recognized that the practice of medicine necessitates a certain level of physical intervention on the human body. The act of administering a medical injection, performing an incision, or conducting a physical examination on a patient are actions that necessitate appropriate regulation and legalization in order to uphold the integrity of the human body. In recent years, there has been significant scrutiny surrounding the relationship between law and medicine due to the emergence of human rights movements and the fast advancements in the technology and medicine. For instance, consent in the context of medical practice is not merely a procedural formality, but rather a legal obligation. Merely obtaining a signature on a document does not constitute valid permission. In instances where a patient is coerced or compelled to provide consent without being adequately informed, the validity of the consent may be compromised even the presence of a signature. Frequently, medical practitioners exhibit a tendency to either disregard or lack awareness of the necessary components of a legally sound consent and the associated legal ramifications. The failure to get consent or the acquisition of an invalid consent has been a topic of examination in numerous medical malpractice lawsuits. Aids the investigation process. For instance, the presence of medical legal competence plays a vital role in the process of death investigation. The primary objective is to furnish impartial evidence on the cause, timing and manner of death, which can be utilized in the adjudication process within the criminal justice system. In cases involving homicides like murder, suspected homicides or attempt to murder and other instances that are deemed suspicious or obscure, it is imperative for the medico legal expert to conduct an on-site visit to the location where the death occurred prior to the removal of the deceased individual's body. In numerous instances, the process of scene investigation holds greater significance than that of the autopsy. Conducting a comprehensive and exhaustive inquiry typically results in the accurate determination of the etiology and modality of death prior to the performance of an autopsy or postmortem examination. The forensic medicine specialist or forensic pathologist possesses the capability to provide guidance to the investigative agency regarding the characteristics of the deceased individual demise. This includes confirming the occurrence of a homicide through a particular method, assessing the circumstances to align with an apparent natural death, or interpreting the blood loss from the deceased individual as more plausibly resulting from a natural ailment rather than inflicted injury. Aids in evidence making. The primary purpose of medical evidence is to provide judges with the guidance in making informed and logical choices on the adjudication of criminal cases. In criminal trials involving charges of murder, manslaughter or bodily harm, the court often relies on medical evidence or the expert opinion of medical professionals to ascertain various aspects. These include determining the cause of injuries, assessing their potential to cause death, and identifying the likely weapon used to inflict the injuries. The inclusion of expert opinions is a common and necessary practice in the adjudication of criminal cases. Drawing upon a scenario in which the defendant may seek legal recourse based on the grounds of mental unsoundness or insanity, it is the medical evidence and the corresponding scientific methodology that substantiate the presence of insanity or a mental unsoundness. Medical evidence, regarded as expert testimony, holds substantial importance and serves as an essential component of evidence, particularly in cases pertaining to crimes committed against women. Consequently, the government has established laboratories and other organizations throughout the country to furnish scientific services to the criminal court system. The determining factor in the court's decision to find in favor of either the prosecution or the defense primarily hinges upon the evidence presented throughout the court proceedings. So, the aids in the understanding of health policies. To have a comprehensive awareness of the current landscape of medicine, it is imperative to possess a foundational knowledge of health policy. Legal variables have a crucial role in shaping a patient's healthcare experience, encompassing a wide range of concerns such as intellectual property and medical negligence. These factors have the potential to significantly impact the outcome and quality of treatment received by individuals. Although it is commonly believed that legislation hinders the field of medicine, it is important to recognize that it can also serve as a means to enhance it, provided that there is appropriate access to relevant information. Aids in hospital administration. There exists a multitude of regulations that ensure the adherence to appropriate registration procedures during the construction of hospital facilities. These regulations further guarantee the safety of these facilities for public utilization, while also ensuring the provision of essential infrastructure commensurate with the projected workload and volume. Additionally, periodic inspections are conducted to verify compliance with these regulations. The laws that pertain to hospitals and their commissioning encompass a range of legislation. These include the Atomic Energy Act of 1962, the Companies Act of 2013, the Indian Electricity Rules of 1956, the National Building Act of 2005, the Radiation Protection Certificate from Bark Society Registration Act, the Urban Land Act of 1976, and the Indian Boilers Act of 1923, and the Clinical Establishment Act 2010 for various health care sectors, amongst others. Doctors experience a significant advantage while acquiring knowledge of business legislation. The healthcare industry is a substantial sector experiencing rapid advancements in technology, business models, and operational efficiencies, particularly in India. In recent times, there has been a notable increase in investment in both disruptive healthcare startups and conventional healthcare enterprises. This trend is indicative of the potential development trajectory observed within the healthcare industry. Physicians frequently assume leadership roles within the healthcare sector, a position that is well deserved. So, coming to the legal practitioner need to know with medical knowledge. Introduction. It is an undeniable that legal expertise, trial experience and other tools amassed by attorneys over the course of their education and careers are crucial in assisting victims through their legal situation. However, a medical background is equally indispensable, particularly in cases involving birth injuries and medical malpractice. An enhanced understanding of injuries. Many personal injury attorneys gain much of their medical knowledge incidentally as part of their daily jobs. However, their understanding of injuries and the practice of medicine is limited. Clients can benefit from advocates who have a deeper understanding of their physical injuries, medical needs, and prognosis by working with lawyers who are also doctors. This enables such lawyers to not only investigate how and why injuries occurred when attempting to meet the burden of proof in civil lawsuits, but also to better understand the severity and impact on victims when seeking compensation for the full scope of their damages. Negotiation leverage. The majority of personal injury cases do not go to the trial. They are frequently settled out of court with insurance companies or corporations. As corporations, these parties have a vested interest in protecting their bottom line, and they frequently prioritize profits over people when attempting to dispute or deny liability for victims' damages or underpay their claims. Knowledge is power, and a better understanding of injuries, treatment, and future medical needs give the team the clout to level the playing field with the most powerful corporations, compel defendants to view victims as people rather than numbers, and secure the settlements clients deserve. Insights of in-house expert. Attorneys without medical degrees frequently consult with medical professionals to support their arguments and strengthen their clients' cases, particularly in cases involving serious injuries and complex cases involving medical malpractice. In fact, due to complexity of medical malpractice claims and the need for resources and professional connections, not only personal injury lawyers handle them. They can draw on diverse insight that most lawyers are forced to obtain from outside experts. This can allow for a more streamlined approach, cost savings associated with hiring medical experts for insight or testimony, and fruitful and meaningful collaboration with specialists in the field. Thorough investigations. Serious injuries, medical malpractice, and birth injuries necessitate thorough and diligent investigation. Medical knowledge and education have played a significant role in the thousands of cases investigated by attorneys. For example, in birth injury cases, understanding of the professional standards and duty of care associated with the practice of medicine enables the attorney to target and identify serious breaches, substandard treatment, and acts of medical negligence that can eventually form the basis of legal claims. So, coming to the translation at trials, the process of translating spoken language in a courtroom setting in instances where legal action becomes imperative, particularly in high stakes litigations involving influential corporate defendants. The intricate nature of the medical matters at hand might present significant obstacles. The position of medical background equips attorneys with the necessary skills to address these obstacles encountered during investigation and pre-trial preparation. Training as trial lawyers complements this knowledge by including the art of effective presentation and persuasion. There are various factors that can determine the outcome of trials, and attorneys who excessively rely on expert medical testimony, intricate details of injuries that are beyond the comprehension of the average person, or superficial medical explanation may hinder the jury's comprehension of crucial fact and their final verdict. By integrating the disciplines of law and medicine, such lawyers with medical knowledge strive to effectively communicate complex medical information in a simplified manner. They prioritize key concepts and facts and construct concise and persuasive arguments that resonates with both juries and judges. Safeguarding patients' interest. Attorneys having the knowledge of medicine offer numerous benefits to families and the victims enduring the tragic repercussions of medical negligence. Beyond providing assistance to victims in navigating their individual trajectories, the endeavors of attorneys can yield far-reaching consequences. Advocates for patient families and medical professionals who hold providers accountable for their actions, frequently despite their attempts to evade liability, are instrumental in ensuring patient safety. By means of legal recourse, heightened consciousness and responsibility, these endeavors may serve to incite essential transformations and avert subsequent occurrence of analogous atrocities. So, now the amalgamation, how the doctors and lawyers profession with together can, with their knowledge of medical knowledge as well as the legal knowledge for both the professionals can help. So, must the doctor should know the legal knowledge and the lawyers should know the medical knowledge will help a lot for the community as well as the victims and their families. So, the doctors and the lawyers in environments characterized by the thriving of innovation and diversity, a distinctive amalgamation of specialized knowledge is arising at the convergence of the fields of medicine and law. Doctor lawyers are those who possesses both medical and legal credentials, assuming a unique and essential function in effectively navigating the intricate legal and ethical terrains of the healthcare field. The amalgamation of knowledge in this context introduces a novel aspect to the field of legal practice, particularly in relation to medical negligence and healthcare legislation. It will help a lot, like the lawyers having the medical knowledge and the doctors having the legal knowledge will prevent lot of the medical negligence happening in the society and community. The individual's varied range of abilities enables them to effectively connect medical practice with legal processes, so providing a holistic viewpoint on matters pertaining to healthcare professionals, patients and institutions. The principal role of doctor lawyers is to offer specialist legal advice to healthcare practitioners and medical institutions. The doctors and the medical institution should have the legal knowledge through the specialist, so that they can have a complete law and the legal knowledge which they can play a role in their medical routine practice and prevent any litigations happening in the future. Due to their comprehensive knowledge of medical practices, procedures and standards, they are capable of providing well informed advice on topics including medical negligence claims, malpractice litigations and healthcare legislations. Doctor lawyers possesses a distinctive set of skills that enable them to effectively examine medical records, especially the medico-legal records, assessment of treatment protocols and determine compliance with established standard of care and standard of treatment in particular instances of medical negligence, whether the doctor has taken care of standard of care and the standard of treatment while performing any operation or in undergoing the treatment of patient, which will be very helpful in case of medical negligences. So, coming to the in conclusion of our lecture 5, which have an amalgamation of doctor and the lawyer's professional knowledge. So, the professions of law and medicine are highly esteemed and held in high regard. Both professions exhibit shared issues and areas of intersection, necessitating the utilization of legal and medical skills for the betterment of society. There is an intersect between medicine as well as the law. So, the common area, if having a both the sides knowledge to particular one person who has an intersect between medicine and the law, having complete knowledge of medicine as well as the legal knowledge will help a lot for whole society, whole community. Healthcare workers who have received education in the field of law are equipped with necessary knowledge and skills to effectively navigate complex legal issues that arise in the medical field. The doctors who have a legal knowledge, they will not fear while giving any testimony, while coming to the court, while dealing with such medical negligence cases. They will not refuse or they will not fear while doing any operations. If they know all the complete legal knowledge, they will do the proper channel, they will follow proper procedure, proper standard of care, and they will not face any litigations or medical negligence cases in their routine medical practices. So, in the context of legal proceedings, attorneys may solicit an expert report for the purpose of medical evaluation. Courts may call for expert evidence to resolve the legal proceedings at hand. So, these were the references used, the various PubMed articles, medical ethics and nhsrcindia.org website. So, all these are the references, you all can go through it for the further knowledge and for the benefit of the whole society and the community. Having both the type of professionals knowledge will help a lot to the community. Thank you very much.